And welcome to Talking Point. I'm your host, Dr. Corey Wright, coming to you live from the studios of the Ghana Broadcasting Corporation in Accra. This is Heritage Month, so I say to you in Dagbani, Anuwula Amaraba. We come to you live this and every Sunday with issues of national concern, and we engage you in discussions for informed decision-making. We are also streaming live on GBC Ghana Online, on Facebook at Ghana Broadcasting Corporation, and as always, we welcome those listening to us on Unique 95.7. The Ecowas Court of Justice is the principal legal organ and regional court of the 15 member states that make up Ecowas. A key element of the annual work program of the Court of Justice is the external court session held in the Court of Member States. On Monday, March 21st, Ghana will, for the very first time, be the host country for the external court session. The judicial power is the least visible to citizens, mainly because it is the one that least intervenes in public debate. However, tonight, along with our learned guests, we will learn more about the Ecowas Court of Justice and why it is an important part of the legal apparatus of Ecowas. We encourage you to join in the discussion by sending your messages during the show to our WhatsApp number 055-744-6429. With me for tonight's discussion are from my extreme left, the Honorable Justice Edward Amoako-Asante, President of the Ecowas Court of Justice. Welcome.
Thank you.
And on my far left is Mr. Tony Maido. He's the Chief Registrar of the Ecowas Court of Justice. Welcome to you both. So I'll start with you, Honorable Justice. When many of us think of ECOWAS, we think about it in terms of the trade and the other economic benefits. So hearing about the ECOWAS Court of Justice for many of us is just about the first time. So maybe you could talk to us a little bit about the genesis of this Court of Justice.
Yeah. Thank you very much. Yes, the ECOWAS Court was set up under the treaty, the main treaty that set up the ECOWAS also set up the court, except that the court didn't function immediately. As you know, generally, is the economic side of it, the executive that took place very well. So later, the court was set up in 2001, though ECOWAS came into being in 1975, as you know. So in 2001, they swore in the first set of judges, who were 7, in Mali in January, and the court started its work. And that is how come the court is very least known, actually. And then generally, because of the kind of work the court does, the jurisdiction and all that is not well known. ECOWAS law is not taught in all the universities, most of them, except in Nigeria and a few more countries. That is why it's not known. But basically, it is there. It's functioning very well, giving people justice that they deserve, especially indigent citizens of the community. Okay.
Yes. So if I can come to you, Mr. Maido, as I mentioned in my introduction, Ghana will host this court for the first time, the external court. Why has it taken you guys so long to come to Ghana? Since 2001.
Yeah.
Well, because, you know, there are 15 member states, and this program is only done once a year. Okay. And due to the COVID pandemic, for about 2 years, we didn't have the opportunity to hold it. We had one in October in Côte d'Ivoire here, and it was decided by the management of the court that this year we must come to Ghana, and that's why we're here. I believe that it would have been nice if we had been able to come here before now, but there are many factors that we take into consideration.
So in 2019, you were here for a sensitization exercise in Ghana, or no?
29.
You were not?
No.
Okay. All right. Okay. So, Honorable Justice, if I can ask you, how does the court work in relation to the national courts in member states?
Yeah. Thank you. The court actually has its specified jurisdiction, which is mostly for now is a human rights court, I would say so, because about 95% of the cases before the court are matters of human rights violations in member states against their citizens or even corporate bodies. That come before the court, about 95% of the rest is just ECOWAS public service issues, like staff of ECOWAS against the institutions or institutions among themselves. But then the national courts, you know, have a very wide jurisdiction. Then the ECOWAS court, we've said it several times, it's not an appellate court over the national courts. We only do our work. Mostly people start cases from the scratch in the court. And when we try as much as possible to resist cases that are pending before the national courts, that come before the Ecowas court. In that case, there's in law something called lis pendens. So you choose your court, you go to the national court and have your matter sorted out there. Once you've started there, the Ecowas court will not pretend to have jurisdiction to do that kind of case. Okay. So that relationship is very, very cordial between us and them.
So let me stay with you because you mentioned the human rights. The amended protocol states that the court has jurisdiction to determine cases of violation of human rights that occur in any member state.
Yeah.
So the definition of, there's no definition there, it just says that very broadly in terms of characterization. So how do you determine the scope of this human rights mandate when the categorization is so broad and sweeping?
Yeah, I think Article 4 of the revised treaty said that the countries who promote human rights in their countries, that's the revised treaty of Ecowas. The countries who uphold and promote human rights in terms of the African Charter of Human and People's Rights. Okay. That's the basic law. Then subsequently, when the protocol on good governance, democracy and good governance was also done, the same was said in that protocol. And therefore, basically, that is what the court intended to do. But then, bear in mind that most of the states have also signed on to other international human rights treaties, like the basic UN Charter, the International Convention on Civic and Political Rights, which all of them, CEDAW and all the kinds of human rights instruments. So the court has said that outside the African Charter, which the laws have permitted us to use, any human rights convention that any of the member states has signed to will be applied to them. So if state actors in those countries default, they violate any right in terms of those treaties, the court applies them against those states. So that's how it works.
All right, so Mr. Maidu, if I can ask you, how long will you be in Ghana? Where will you be holding court? And what kind of cases will be viewed at that time, if you can speak to that?
Okay, we are going to be in Ghana for 2 weeks.
2 weeks.
From tomorrow, Monday 24th, until 1st of April, when we're rounding up. So most of the cases we are going to handle pertain to human rights violations, not only against Ghana, but against many other neighboring states. So
and where will you be having
at the Law Course Complex.
Okay.
Law Course Complex.
All right, so one thing of Ecowas, one of the challenges we face is a language barrier. So how does the court address that challenge?
The court works in the 3 official languages of the community, English, French, and Portuguese. Okay. So the processes are usually translated into these 3 languages. And secondly, we have interpreters that even when the court is working, the court works in the 3 languages, English, French, and Portuguese.
Okay. And does that have an effect in how long the cases take, because the translations have to be made before a decision is reached?
It does, but we try to be as efficient as possible because it takes time to translate these documents into the 3 working languages. Internally, we have translators and interpreters, but often we find out that we are not able to cope because of the volume of work. So sometimes we resort to the services of freelance translators and freelance interpreters.
Okay, so Honorable, if the mobility aspect in terms of moving to member states, is this something unique to Ecowas, or do other regional courts have that same?
The other regional courts I know not of. Okay. I think they do not. We visited the European Court. They mentioned no such thing to us, as well as the International Court of Justice. They also do not do those things. But our rule specifically says that when the need arises, the court can sit in any of the member states. And this is intended to help the indigent citizens who have no means of moving around. Luckily now, well, luckily or unluckily, the COVID has resolved almost the issue, because now we do virtual hearing. Most of our hearing are on Zoom, and therefore parties and their lawyers may even be in their countries and still log in, and the hearing is done. Even witnesses can be in their own countries and still log in and give their evidence, and therefore that is how it works. Okay. So they necessarily don't have to move now, but hitherto they used to move to Abuja. Okay. Yes.
So Mr. Maidu, if somebody is listening and says, oh, I think I have a case that may be of interest that I should go to the court, what is the process? Is that something they have to pay? How would they start all that?
Usually the processes before the court, you don't pay for them, they are free. you file your processing free of charge. And just as my Lord has said, it's easy to file all these things remotely now. You don't have to come physically to the court. But what is required that you submit your initiating application to the registry of the court in Abuja. Before now, you had to come physically to come and file at the registry to lodge your initiating application. But that is no longer necessary, because you can do that remotely now, simply by sending us an email. What is required for you to comply with the template as provided by rules of procedure.
Okay, so I wanted to ask you about when you talked about jurisdiction. One of the documents I was reading that was sent to me talked about the court has competence to adjudicate in disputes relating to the legality of regulations, directives, decisions, and other subsidiary legal instruments adopted by Ecowas, or the failure of member states to honor their obligations under the treaty conventions, yada, yada, yada. So in 2017, there was a dispute between Ghana and Ivory Coast, specifically as it related to the international seas, the maritime. And so it was tried in a Hamburg-based international tribunal of the law of the seas. Is this something that could have come to ECOWAS, or is that something that ECOWAS, there was no jurisdiction there at all?
Basically, looking at the basic text that set up the court may not have jurisdiction, actually, looking at the kind of case it is. But our rules also permit parties to agree to come to the ECOWAS court to have their matter determined. So even if it is whatever kind of case it is, apart from maybe criminal cases where the court doesn't have the jurisdiction to deal, if parties agree that let's go and resolve this issue at the ECOWAS court, it can be brought for the ECOWAS court to determine it.
Okay.
Yes, that is.
So you mentioned earlier about the translators and the judges also. What are some of the challenges that the court faces right now?
The major one is the issue of compliance with the judgments of the courts, issue of enforcement of the judgments of the court. The 2005 amendment of the court, gave the member states the opportunity to appoint competent national authorities that will be responsible for the processing of the writ of execution of the judgments of the court. Unfortunately, out of the 15 member states, only 6 member states have appointed that competent national authority. So that is one failure by most member states to appoint that competent national authority for the enforcement of the judgments of the court. That is.
So you mentioned 6 of them. So I have Burkina Faso, Guinea, Mali, Togo, Nigeria. Who is the 6th one?
Ghana.
Ghana, thank goodness. I was going to ask because I didn't see it in my notes. That's good to know. Okay, so what happens with this is that when the decisions are made on your end, the corresponding body internally makes sure that the decisions are honored.
Yes.
Okay. All right, and that's where, and the other gap I think you mentioned was also the judges have been reduced from 7 to 5.
Yes.
Why was that? Do you know what the thinking behind it? Because the original document was for 7 judges.
Yes. We had the institutional reforms in ECOWAS that has been ongoing for quite some time. In 2017, 2018, it was decided to reduce the political appointees in ECOWAS. For instance, the commission was reduced from 15 to 9. 9 commissioners. In that same process, they extended it to other ECOWAS institutions, and the ECOWAS Court of Justice, the members were reduced from 7 to 5. And for instance, JABA was statutory appointees were reduced from 2 to 1. The same for JABA from 2 to 1. So it was an institutional. But what we have always contended that ECOWAS Court of Justice is a peculiar institution. It should not be treated like other political institutions of the community. Even
though the appointees are political appointees?
Even they are
yeah.
So, but these are judicial officers, So that is one challenge. The other challenge...
Before you go, I wanted to ask the Justice what impact that may have had on the cases that you are able to review or that are pending before you.
Yeah, it has got a very big negative impact. Actually, the court sits in a panel of 3 judges. And therefore, now we can set up only one set of judges at a time. So if one judge travels, another is not well for some reason, cannot sit, then the court is handicapped. So these are most of the, and then generally, as you mentioned about the translation, cases are translated based on the language of the judges who sit on the case.
Okay.
For instance, now we have 3 English judges in the set.
English
and therefore, yes, and therefore, if a case is placed before the 3 judges, there is no need for translation if it's an English case. And therefore, if we had 7, you could see that there could be 3 French, 3 English, and 1 Lusophone, for which reason most of the cases would have been heard without translation, which is too much cost to the court. Using freelance translators is a big issue for us now. So the budget is seriously hit. So if you are 7, 3 English, they could do most of the French cases. Then 3 English could also do the 3 English cases. Then few times they may be mixed up for translation. In that case, there would have been less translation, less time wasted, because the translation takes a month, 2, 3, 4, or 5 before it is done for the case to go on. Yes.
So was there another challenge that you may have wanted to add, or?
Yes, concerning the tenure of the judges. It was in 2006, the tenure of judges was reduced from 5 years renewable to 4 years non-renewable. And that's the shortest tenure you find among regional courts. Courts like even the International Court of Justice has 9 years renewable for another term of 9 years. But now, in the case of Ecowas, it was reduced from 5 years renewable to 4 years non-renewable, which we feel is too short. It definitely has a negative impact on the courts.
So overall, how many cases has the court looked at so far? What are some of the decisions that have come out of it? How many cases are pending? Just to give us an overview.
Since its inception, 584 cases have been filed. The court has given 131 rulings and 305 judgments. It has equally given 24 decisions on revision, but now we have about 178 cases pending for the courts.
So the decisions that you've made, I just want to tie it back to the implementing organ in the host country. How many of them have actually gone through the entire process and the implementation has been complete? Do you have that information?
Roughly about 30% of the cases have been complied with.
Okay.
About 30% by member states.
So what I'll try and do is ask questions as I go along from the viewers and the listeners. There's one here that says, "Good evening, my name is Rufai. I want to know if there are discussions to consider Arabic language as part of ECOWAS official languages, since some parts of Nigeria, Niger, Gambia, Senegal, etc. speak and write Arabic." Maybe I'll ask you that, Justice.
Thank you very much. We are a court. We're set up by statute, and we are generally, courts or judges are slaves to the executive. It is they who pass the laws through parliament, and then we implement. And therefore, if they say so, it will be done. Otherwise, we may not. Except that if we see the prevalence of such language in our court, then maybe we may also make a recommendation to them, which hasn't happened yet, because most of the indigent witnesses that come before us speak English, and therefore we have not had the opportunity to interact with any such persons with that language.
Okay.
Yes.
So there was also a part of the supplementary protocol that gave you exclusive jurisdiction for referrals on the interpretation of community text. And from what I understand, both of you have expressed the concern that no country has so far referred anything to the ECOWAS. Why do you think that is? I'll ask both of you your feedback on that. Why do you think that has happened, and what is being done to encourage that symbiotic relationship between the national courts and the ECOWAS Court of Justice? If I can start with you, Honorable Justice.
That hasn't been done, actually, as you say, and as we've expressed the desire for it to be done. But it depends. It's likely that the cases of such nature haven't gone before the national courts, and therefore the interpretation or whatever of any ECOWAS text issue hasn't come before any of the national courts. If they have, the judge may also pretend to know how to interpret the law. If especially it's a very clear, straightforward interpretation, he may think he knows how to do, and therefore he may not bring it before the ECOWAS court. Looking at the time that it will take to refer the case to the court, that case may be on his course list for a very long time, when he could also just look at the direct interpretation and do it. I'm sure that is one of the reasons. But then, to forestall that, that's one of the reasons we are here. We do sensitization in most countries, most times. These are trying to see the relationship between the national courts and the ECOWAS court as a very cordial one. Say that the fraternity will be there. Let them know their responsibilities, our responsibilities in terms of relationship, so that those things can be carried out appropriately. Yes.
Do you want to add anything?
Yeah, in addition to what my Lord has said, I think that more effort has to put in towards the development of an ECOWAS legal order. At best, what we have now is an ECOWAS legal regime, but the relationship between the regional court and the national court has to be improved upon, because you see now that the synergy is not very strong between the regional court and the national court. That is what is responsible for that, and there are many factors. You look at the domestication of the Ecowas revised treaty. Most member states have not done that. You look at the domestication of the other supplementary acts of the community. Most member states have not done that. And for the courts to be able to invoke Ecowas community law before them, they must have implementing legislation, which is absent in most member states. So more work really needs to be done there, because the revised treaty actually provides for the harmonization of the judicial and legal systems of the member states, which equally has not been done. So there are a lot of work, areas that there are gaps that member states really need to take the initiative by domesticating, ratifying, and putting in place the necessary legislation that will enable the national courts to act on these matters.
So I don't want to ask you to put yourself in the shoes of the other countries, but in the case of the competent national authorities, for example, why is it that you think only 6 of the 15 have actually established, and what bottleneck do you think exists that could allow more countries to actually embrace that and establish the national entity responsible for implementing or assisting in the implementation of the decisions?
It requires political will. Absolutely at the discretion of the member states. The court can only appeal, and we have done that repeatedly. We have written them to them repeatedly. So we are still hopeful that as time goes on, that more member states will appoint the competent national authority.
Okay.
But it's a matter completely within the purview of the member states.
Okay. So, Honorable Justice, if I can ask you, there were supplemental protocols that were adopted and changed the initial focus of the course, if I have that right. Why was it important, do you think, for those protocols to be adopted, and how does that change the jurisdiction and mandate of the court?
Specifically, that is the 2005 supplementary protocol. That before that, the court was an interstate court, purely to determine matters, disputes between member states, and also to interpret and apply the Ecowas treaties between the member states or among them. And therefore, at the initial stages of the court, 2001 to about 2004, there were just about 3 or 4 cases filed before the court, because the interstate court, individuals had no local standby to come before the court. It was only in 2005 when it was amended and said individuals had the right to come to the court, and also gave the court the mandate to deal with violations of human rights within member states by state actors or corporate bodies and all that, and also give corporate bodies the right to come to the court for violation of certain rights of theirs. That was when the court started. And therefore, this is what has given the court its pedigree now. And that's why I'm saying about 95% of the cases now are human rights violations within member states.
Okay.
Yes.
I still want to go back to the community court concept, because I find it very interesting. Why do you find it important, Samaido? Why is it important for the Ecowas Court of Justice to actually situate itself within the member states rather than staying in the headquarters? Is it because of access? I'm just trying to figure out some of the reasons why you believe that's an important component of the work of the Court of Justice.
It is important because the court has the opportunity, when it is necessary, to reach out to member states. As my Lord stated, sometimes we have indigent citizens that cannot afford to come to the seat of court. So it is important that the court seizes this provision in its protocol to reach out to such indigent member states by bringing justice to the grassroots of the community.
So when you talk about, go ahead.
And to add to that, for instance, there are some lawyers who may not even have heard about the Ecowas Court at all, or practiced before it at all. Now, the advert is all over the place. There are lawyers within the country. In their free time, they can come and sit in and watch how the court works, the procedure, everything. Or who knows, they may also even get cases and try to come before the court and practice, because the court belongs to all of us. It's all the member states that own it, that fund it, and therefore it is only desirable that everybody tastes the court. Yes.
Okay, so I just wanted to ask, we talked earlier and you said that there's a clear distinction between what you do and what the national courts do.
Yes.
So in the case of a human rights case, which are the cases that you adjudicate, national courts also adjudicate on those matters. So what is it that differentiates the ones that come to you versus the one that go to the national courts?
Okay, yeah. it's true that the nations have human rights laws within their constitutions, separate human rights acts within them. But that of the ECOWAS court is distinct because it is the violations by state actors. When they act, for instance, somebody can bring a case for non-enforcement of a judgment if it's through the indolence of the judiciary. That's a human rights violation because he has a right to have his judgment enforced. And since he's a state actor, he may not want to sue the judiciary here because he may know the he may think that there's a bigger force than him, individual fighting the whole. So then in that case, he comes to the, which has more of a regional nature than going to a high court in Accra or in Ghana here. So that is some of the distinctions between the two. So ours is basically state actors, police, soldiers, and all that, who have the might, who have the power to do certain things, who do it before, against individuals or corporate bodies and violate them. Then in that case they come. But they can still go to the national court though, but well, they prefer to come to the ECOWAS court.
And like you said, once it's at a national level, you don't, national court, you don't get into it.
Yes, at all.
All right. So I have another question here that I'll ask you, Mr. Maido. It says, Madam Host, kindly find out from your panelists, some major cases from Ghana have come before the ECOWAS court, and the decisions taken and the people who initiated. Oh, I think they want to know what kinds of cases major cases may have come. I guess this both either of you can answer. What are some of the major cases that have emanated from Ghana that have come before you, and what are some of the decisions taken and the people who initiated such cases? It's pretty broad, but maybe you can give an example or two.
Okay. Well,
and this is from Togbe Agama in Accra.
The chief registrar is older in the court, so he may know more. But those that I know, one is Chido Imba, a popular Chido Imba case. It's a Nigerian British citizen who came to Accra. He was doing some business, had his a truck seized by the security services, and the goods got damaged over a very long period before they released it to him. And therefore he sued the Ghana government for the security indolence and all that. He had damages before about $800,000 before the ECOWAS Court of Justice, because that was the value of the items seized. And Ghana actually didn't defend the matter. And therefore, judgment was entered. And he came, unfortunately, Ghana, they served Ghana, but they didn't pay. So he came to the High Court in Ghana to try to enforce the judgment. And as the law is clear, Ghana had then, even now, not domesticated the ECOWAS treaties, the treaties on the court, and therefore the High Court threw it out, said it was not possible to enforce that judgment. Then there's a current one that is coming on now, and therefore we cannot talk about it. There's one coming on Wednesday. It's a case against Ghana. I guess there are other older cases. There's one or two that the chief registrar may talk about.
So, older gentlemen, if you can give us some information about maybe one or two.
Mentioned the two most important ones, so I'll leave it like that. Like Chudemba and the Bakari case, two of them.
So it's interesting because I thought the justices or this group of individuals were sworn in or inaugurated in 2018. But you were there longer. This is your second term. Okay.
Been there for
2001.
2001. Wow, congratulations.
Thank you.
Okay, so I have another question here. My name is David Osea Samoa. It has just been indicated by Mr. Nene that only 30% of rulings have been complied with by the affected member states. This means that 70% of the rulings are not complied with by the affected members. My question is, does that not make the ECOWAS court powerless?
Not at all. It's a challenge that most international tribunals have because we don't have cohesive organs to enforce our judgment. The judgments of the court are enforced by member states using their own internal machinery. So it's a responsibility, but the fact that the ECOWAS Court of Justice has made a pronouncement condemning any member states is a very strong statement that is recognized internationally, and we never lose hope. I'll give you an example. During the reign of Jammeh in Gambia, most of the judgments were not obeyed, but the change of government Justice Barrow, the President Barrow's government, they are complying now. So it's never too late.
The decision is there.
It's there and can be complied with
political will, like
you
said, is available.
Can be complied with at any time.
Yes, and if I may add, the political will, but then you find out that naming and shaming, if it should be part of it. We spoke to the judges of the European Court on Human Rights and the European Court of Justice. in their system, which is more developed, this same thing applies. Countries comply by will. But then, if countries are listed to be reneging on their international obligations, because complying with the court judgment is also part of your international obligation. And therefore, if that is done, there are certain positions, key positions in the Union, which are distributed and shared among member states. So countries who do not comply with those duties are denied those positions. Those are some of the sanctions that the countries themselves, if they are seriously willing to do justice, do against those countries that do not do it. But here, well, it's a bit lacking, but we hope for the best.
So we have another question from Portia Sheffer. I would like to know, with your current initiative of making ECOWAS court accessible to member states, will there be the need for more appointment of justices from each state in order to make the courts more accessible, looking at the workload, especially in respect to the human rights actions? I know you've answered it in a way and said it's actually been reduced, but maybe you can give a summary for Portia.
Yes, actually we do. We need an increment in it. Maybe not one per state. Yeah, 7 or 9, that should be fine. Even more critically is an appellate court. That is very important, because the protocols say that the judgments of the court are final and enforceable, and there's no appellate court, and therefore to test the judgment of the court. Maybe that may also even be one of the reasons the countries may not be wanting to enforce the judgments. So if they create an appellate chamber by increasing the numbers, some are the appellate judges and some are the trial judges, that may also help. So I agree with her. We seriously need to increase the number of judges. But then it's all financial issues. This reform they are talking about was based on financial matters. Yes.
Interesting. So, Mr. Maidu, there was an article that I read where there was a sensitization of a stakeholders forum. It says Accra, but when you said you guys never came to Accra, I'm assuming that maybe it was in Nigeria or something.
For this program.
Yeah, okay. So it just says, no, this was in 2019,
yes,
2018, December 2018. Yes. So I was just wondering, how did that go when you were here? What kind of sensitization efforts were you hoping to engage with the ministry, and how well did it go? And do you embark on this on a regular basis with member states?
What we did was a training program for judicial officers, law students, and the academia. It was a training program in which we brought lecturers from universities, we brought practicing lawyers, and we brought law students. So it was a kind of training program for them to teach them, or to talk to them about the mandate of the court, the practice and procedure of the court, and the competence of the court. What I said was that we have never had an external court session here, but we have conducted other programs here in Ghana.
Okay, yeah, I was actually talking about that. So it was for 4 days?
Yes.
Okay, and do you do that in other countries, or other member
yes.
states? Okay.
We do too.
All right, okay. So you have at least visited us before in 2018.
Yes, we have done other programs. Even in 2019, we had an international conference here in Accra.
Great.
So we have had other programs here. We were specifically talking about external court session. Apart from that, other programs of the court have been carried out here
in Ghana. Yes. Okay. Honorable Justice, the current mandate of the court has been indicated here as Community Court, ECOWAS Public Service Court. Yes. I wondered what that meant, Public Service Court.
Yeah, that is for staff. You know, ECOWAS has a lot of staff. And in Parliament, in the Commission itself, in the court, JABA, there are so many institutions of ECOWAS. And the staff may have grievances if there are disciplinary matters against them, and they are not satisfied with the situation, they can go to court and come to the ECOWAS court. Currently, there are so many of them, people who have either been dismissed or suspended for 1 or 2 reasons. You know, wherever there are staff issues, those come in. So if they go through they exhaust the procedures within the system and they are still not satisfied, they can come to the ECOWAS court. So that's the description for that. Okay,
and the community court is the external, is the one you're doing here in Ghana, or is that something different?
Yeah, no, this is...
Okay, and then arbitration tribunal.
Yes, that's one of the mandates of the court, but it has not been set up. The system, the laws say that there should be that, but the procedures, you know, arbitration has its own separate procedures. That has not been set up, and therefore this court is said to be acting in that state until that is set up. So it's only in an acting position. So as I mentioned earlier, people can bring their own cases and agree in their contract that the Ecowas Court of Justice should be their arbiter. And if that is brought, the court deals with it.
Okay, because there are lots of contracts, right, and memorandums of understandings, what have you, that are signed by, between Ghana and some other country. And many times, we talk about the court systems in Ghana or the court systems in the other country. Right. Could ECOWAS be one of the
yes, if the parties agree, yes.
All
yes.
Right. That's interesting. Okay. There's a question here that I'll try and rephrase. This person wants to find out if ECOWAS has any jurisdiction over some of the countries where there are coups taking place, and if there's a way to bring those coup leaders to justice, and that is there any sort of jurisdiction that you may have? For example, you have the courts in the other countries, European courts, and where human rights violations, what have you. But maybe if I'll ask.
Yeah. As I said, the court is a creation of statute, and the statute that sets up the mandate and the jurisdiction of the court. Talking about coups, trials, we are going into the realm of criminal trials, and the court has no such jurisdiction. But if, in course of elections, there are issues of rights violations which normally come. For instance, there was a case in Senegal where prior to the elections, they changed their laws and made it said that a presidential candidate will have to have about 5 million or so people to sign for him before he is eligible to contest elections. Clearly, that was the way of trying to push out other candidates. So that's a rights violation. So they came before the Ecowas Court and we said that law, well, we could not whittle down the law, but then we declared that that law is not up to international best practices and even up to any of the international election laws or even human rights laws that they themselves have. So they are denying the people the adult suffrage, and therefore we hear there are steps within the country to try to amend and change those laws. So that is one. But talking about trying people who do those things, the court has no jurisdiction.
So, but what if it's presented within the context of a human rights issue?
You mean the rigging of election?
No, I'm talking about the question was about people who commit coup, who engage in coup.
Oh,
so
coup.
What if the behavior is couched within the context of human rights? That during the staging of the coup, my rights were violated. Is that something that...
okay. Yeah, those ones. I think there was one in Niger. Yeah, there's a Niger case like that, which is before the court. We've not determined it yet.
Okay.
Yes.
All right. Okay. So I'm going to go back to you, Mr. Maido. You talked about, October 2019, you mentioned that the productivity of the current College of Justices, where they had rendered 35 decisions, and that was a record for the court during the last legal year. I was wondering, if you go back, how is it now? I don't know when the numbers were reduced from 7 to 5, but how many legal cases or decisions are now being rendered, if you compare it vis-a-vis to this that happened in 2018, I think, because we were talking about the last legal year?
The number of judges was reduced in 2017-18. So that was the first decision was taken in 2017. So this current set of judges came in 2018, 5. So they were the first set of judges that implemented the number of judges as being 5 instead of 7. So what we are saying that since they came in, despite the fact that only 5 of them came in instead of 7, they've been very productive. That was why I gave you the figure of the number of judgment they are given. And as at that time, it was the highest given by any college of judges in any particular year.
How did the COVID affect your operations? Did you find that drastically reduced, or because of the introduction of online mechanisms, you were able to maintain delivery of decisions, Honorable Justice?
Initially, it was. For the first 2 months, I think we didn't even work. And then we had to be proactive, so we took the decision, we did the practice direction. That included the use of online means, Zoom means to determine our cases. We trained lawyers in most of the countries that actually practiced before the court. The registry staff were all trained, and it took off. So in May, we signed the new practice directions and started this work. So it was just about March to about April that the court didn't work because of the COVID. But then we took off, and I think things have become normalized. And it's even more, it's faster and more efficient now because of the only issue is that in law, we talk about looking at observing the demeanor of witnesses and parties when they speak. If someone is speaking on Zoom elsewhere, he's even being coached by someone behind, you may not know. So, you know, that's one of the only nuances that we have in the trial. Otherwise, things are normalized.
So, Mr. Maidu, does the court accept all cases that it receives? You know, in some countries, some Supreme Courts, they sift through. They say, okay, this case merits our attention, this case does not. So I'm just trying to find out if there's a similar process at the Ecowas Court of Justice, or all cases that are received are adjudicated upon. At
the registry, we accept all cases because we don't have the right to reject any case. But under Article 88 of the 87 and 88 of the Rules of Procedure, they serve as filter mechanism in the sense that a counsel can raise an objection that a court is not supposed to take cognizance of this type of case, maybe it doesn't have jurisdiction and things like that. So it's a faster track because objection can be raised under Article 87 and 88 of the rules that enables the court quickly to see. So the judge rapporteur will look at it, and if it's not supposed to take cognizance of it, he brings a report before the panel, and they can easily treat that issue.
Okay. So, Honorable Justice, does the court ever decide or set itself some goals or objectives in terms of choosing to deal with any particular case to promote a specific right or not? Does it have that maybe as part of an annual mandate that we will try and do this or that?
No, there's no specific. No.
Okay.
We do generally all the cases that come before us.
Okay. I have one question here that I just want to go here to. On the issue of ratification of Ecowas treaties by member states, I would like to know what can be done to member states who have failed to ratify these treaties. And he or she apologizes if that question has already been asked.
Okay. Well, as I said, Ecowas court will only have to appeal, and civil society. The court relies mostly on civil society and on lawyers who practice before the court. Nigerian lawyers have been very vibrant in the fights for the court. Actually, they were the ones, together with other international institutions, human rights institutions like Amnesty International, and the other SERAP and the others, who fought for the court to be given the human rights jurisdiction and for individuals to have access to the court. So it behoves civil society and all people who want to be beneficiaries of the court to fight for this to be done. For instance, we've had discussions with parliamentarians in most countries. The Ecowas Parliament is full of parliamentarians from the 15 member states. We meet them, we go to their programs, we discuss with them, they have their will, but when they go back to their countries, it is missing. You know, so it's, as we said, it's still part of self-will, self-determination and all that before those things can be done.
So there is not much that can be done to push the states to ratify these treaties, Mr. Maidu?
We'll continue to appeal as we have been doing, but the civil society has a big role to play in that respect. The laws and bar associations have a big role to play in that. But at the end of the way, it's a question of political will. It's for the member states to do.
I have another question here from Mr. Bernard Aintree. What I know in Ghana is that when one sends his or her case to courts, that person doesn't pay for any charges apart from that of small administrative charges. Is it the same at the Ecowas court, or Ecowas court operates as a court of arbitration? I'll ask.
It's free, totally free. You don't have you don't pay for a filing fee when you bring an initial application before the Ecowas Court of Justice. But in the national courts, you pay filing fees. But before the Ecowas Court of Justice, it's absolutely free.
I wanted to just ask what the relationship between your courts and, apart from it being cordial, is there a formal or ongoing or brotherly relationship between the Ecowas Court of Justice and the local national courts? Because, I mean, whilst you're here, do you intend on meeting members of our national courts to have discussions, to, you know, improve relations to ensure that maybe some of these, if there are any treaties that are outstanding and any gap in understanding of knowledge regarding this, where they can be bridged?
Yes, there are always plans, but by the time you realize the year is gone. Yes, because there's a little budget for that, for us to meet courts and judges in national courts, to have discussions with them, let them know more about the Ecowas court. But whatever it is, it all boils down to the country's ratification of the laws to enable them to apply. For instance, I told you about the children back case, where it came before the Accra High Court and they struck it out because there was no domestication or ratification of the Ecowas laws, and therefore they couldn't enforce it. So even if you do all this education, all this PR, everything with the judges, and the parliament doesn't ratify and domesticate the Ecowas laws of enforcement, the judges, there's little they can do because they cannot also apply a non-existent law. But then the relationship, wherever we go, when we visit the countries, we have that done. For instance, tomorrow, they know that the representatives of all the judges are going to be at our program. And subsequently, there are also other programs that are being rolled out to see if we can meet the judges, some of the judges and their reps, to have discussions with them.
Okay.
Yes.
So, Mr. Maidu, you mentioned 2001, I think, is when the implementation started of the external courts. How are the countries where the court decides to go selected?
We said 2001 was when the judges of the panel judges of the court were sworn in. The decision is made by the president of the court. Usually, there could be an application. I'll give you an example. The first two cases that were decided when the court went on when this program started. First one was in Mali, that is slave case. There was a request specifically from Niger and from Mali. I mean from Niger Republic for that case. There was equally another request in Mali, where an 83-year-old man couldn't come to the court and he applied. So those are the very first two cases. Niger was the slave case. There was a request for the court to move to Niger, followed by the one of Mali. There was equally a request by Musa Aliu Keita for the court to move. So there could be a request from an applicant before the court to do so. We'll also look at the number of cases in the particular member states and all the surrounding countries. So it's because we are not treating cases not just from one country, but from all the surrounding countries, that where lawyers can easily come to where we are sitting.
A convergent point. Okay, I have another question here. There's no name, but it says, how are judges appointed to the Ecowas court and what criteria is used? Outside of it being a political appointee, what else? What is the other criteria that is needed?
It's not necessarily a political appointment. The positions for judges are shared among the member states. For instance, in our time, 2018, when they shared the positions among themselves, Ghana, Nigeria, Sierra Leone, Cape Verde, and La Côte d'Ivoire were supposed to bring judges. And therefore, in that case, they tell the countries to advertise within their countries. So you advertise, and then that's where maybe the political aspect comes. So they have to shortlist the persons who qualify. The qualification is you have to qualify to be in the highest court of your country. That is the basic qualification. You have to qualify to be in the highest court of your country as a lawyer or a jurisconsult, a researcher, international human rights or international law jurisconsult. In that case, you qualify. So the country shortlists 3 per country, and then we have the Judicial Council of Ecowas that comprises of all the 15 chief justices, and therefore they converge at a place in one country. For instance, in our time in Lomé, and then you are interviewed, and one candidate is picked per country. So the 15 chief justices do the interview, and they pick one per country, and you are sworn in to be a judge of the Ecowas court. And
it's gone from a 5-year term, I hear, renewable, to a 4-year term renewable.
Non-renewable.
Okay. So you mentioned earlier, Mr. Maidu, how anyone who has a case that they think may be of interest to the court can do it online. Is there a website? How does the process work practically for somebody who's listening and says, I do have a case and I would like it to come before the court? Yes,
we have a website called Ecowas.com, but if you want to send your mail, with your initiating application as an attachment, you send it to registry@courtecowas.com.
Registry@courtecowas.com. And so the forms
.org, sorry.
.org, okay. The forms that people fill, is it complicated? Is it simple? You mentioned many of the people are indigent, so we want to make sure that it's easy. How is it in terms of?
It's advisable for them to be represented by lawyers.
Okay.
Very advisable because it insists on that. There's only lawyers that can do that. We don't have a form as in form of a template, but we have requirements. The rules of procedure specifically what should be contained on the application. Once you follow those guidelines, you are good to go.
Okay. So although anyone listening should understand that although their case can come before the courts, they have to go through an attorney who will help them navigate all these systems. Okay. So Justice Asante, this is for you. Justice Asante talked about the relationship that ECOWAS court tries to form with the national courts. I would like to know if there has been any conflict in their decisions ruling vis-a-vis that of the national courts on the same case, and that is by Portia Sheffer again.
Okay, thank you, Portia. As I said, we do not accept cases that are before the national courts. And therefore, if you start your application or your case before the national court and it is realized, of course, the other party whom you sue will indicate it to the ECOWAS court that the matter is already before the national court. In that case, the ECOWAS court will refuse the case and not handle the case at all because of that clash which the court wants to prevent.
Okay. And she goes further to ask also, when a national court makes a decision on an issue, does it oust the jurisdiction of the ECOWAS court on the same issue, or are they not supposed to take
Yes, the court will not take it at all. Once the decision is made, it is made. So you cannot be vexed twice. You cannot have the matter heard again by the ECOWAS court at all. We will not entertain it.
Okay.
Yes.
So we have here the mandate of the court as a community court also includes giving an advisory opinion. What does that mean?
Yes, there are certain issues. We deal with politicians in the other institutions like the GIABA, that's the money laundering institution. The WAHO is the health institution, and the main commission. There are so many commissioners who deal with agriculture, so many of them health and all that. There are so many texts in ECOWAS, and some of them may conflict. So aside interpretation, we also give advisory opinion. For instance, there was an issue in 2020 or so. So the Auditor General of ECOWAS couldn't find his way clear because of previous decisions that had been taken. And therefore, he wanted an advice, and he applied to the court. So we had to just oppose 1 or 2 or 3 decisions that have been made, and then we gave an advisory opinion for him to apply. So that's how it is.
Okay. So this is very legalistic, so I'm going to ask if you can explain it to me, because I thought it was interesting, but I don't think I quite understood what they were trying to say. It talked about the fact that the protocol of the court gives individual access to the court to apply for release of the violations of the human rights on the condition that the application is not anonymous and not pending before another international court for adjudication. And it goes on to say that the court held that a national court, even the Supreme Court of a member state, does not qualify as an international court.
Yeah, anonymity, so the case should be clear, a clear human rights case. That's the anonymity aspect of it. And it shouldn't be pending before another international court. We know international courts clearly that it's not a national court. Though the ECOWAS court is in Abuja, it is comprised of international judges from various countries, and therefore it's not a national court.
So ECOWAS court is considered an international?
Yes, or a regional court, if you want to call it that way. But then the national courts are clearly those defined within the countries, whose bounds are within the countries, and so it's clear that they are not international courts. Yes, obviously.
So I have one more question. Kwabena Asare from Kwabena in Accra. He wants to know whether the court handles election disputes. As you mentioned, it may be the situation in Senegal, maybe something close.
But that's not a clear election dispute.
It's
Talking about
a
dispute
violation.
Means, yes. I think there's one. There's one from Guinea or so that hasn't been determined. No, Guinea-Bissau, I think he declared himself winner. He says he's the winner of the and therefore the court should declare him winner. It's still sub judice, so we have not dealt with it, so we will look at it when the time comes.
Oh boy.
Yes.
So let me ask you, Maido, you've been there for a very long time. How do you characterize all the different cases? I'm sure it's very exciting, all the different cases that come through and the different judges that you're able to interact with. How is that experience for you?
It's been very interesting. The 2005 amendment that gave the court, expanded the initial mandate of the court, actually was a lifesaver for the court. Because before then, being an interstate court, only member states and institutions of the community had access to the court. So the 2005 amendment was a paradigm shift in the affairs of the court, and it made a huge difference. But as my lord said, the mainstay of the judicial activities of the court is the human rights mandate of the court. And the court was given a human rights mandate that was very indeterminate, it was very vague.
Expansive.
Very vague. But the court has been, used the discretion in fashioning out a very unique human rights mandate that you don't see in any international human rights mandate. And the most important aspect of it is that there's no requirement for exhaustion of local remedies. That you will not see that in any other international human rights court. So that is why it makes it so distinct. The second aspect is that the human rights mandate of the court is very expansive. Both civil and political rights, economic and socio-cultural rights. So there's no limit. So it's only the court has been able to put, some limitations to guide. But apart from that, the mandate is so expansive. And one of the aspects that it is holding member states accountable for their treaty obligations. Their obligations they have assumed under international human rights treaties. That is what the court is enforced. And once you have signed an international human rights instrument, in addition, for instance, the African Charter, the court will hold you accountable for violations of those rights. So the court is not implementing the constitutions of member states. It is the rights, the treaties that they have signed that the court is holding them accountable for. So it's a very interesting and vibrant human rights mandate that the court has been able to fashion out.
So, Honorable Justice, any final parting words?
The parting right is in respect of the enforcement, non-enforcement of the judgments of the court. Actually, the 30% he's talking about is not based on the national competent authority. It's based on self-will by the countries themselves. Yes, because as we've already said, they have not ratified the laws, and therefore even though the competent authorities, who mostly are attorney generals of the countries, of those who have appointed, Ghana's own is the attorney general, and therefore if the judgment is given, it is sent to him, he receives it, and he has to enforce it. But looking at it practically, he is the one who came to represent the country. And therefore, how do you give the judgment to the same person to go and enforce within the country? So it's just funny. But then we'll still call on the authorities that this is their court, a court they've made, which is helping people, declaring people's rights. The bottom line is that even if you are not enforcing, we've declared the rights of certain people, which are very, very important. Some people come for just declaratory rights, not even for money or for damages or for anything, but just so they've won their case. The country, the president or the country, the government knows that they've won their case. But the bottom line is also they incur costs, and therefore it's only fair that if that is done, they should make sure they resource the court, they have the proper mechanisms in place for the enforcement of the judgment. Because I always ask this question: what's the point in having a court, or what's the use of a court if its judgments cannot be enforced?
Thank you both so much for joining us on tonight's Talking Point, and thank you also to our listeners and viewers. Special thank you to Honorable Justice Edward Amakwasante, President of the Ecowas Court of Justice, and Mr. Tony Maido, Chief Registrar of the Ecowas Court of Justice. I'm Dr. Nim Wright, and this has been Talking Points. Thank you so much for spending your Sunday with us, and as always, be safe. Till next week.
Thank you.